Hi, everybody. My name is Jim Hacking. I'm an immigration attorney practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. In today's video, we're going to cover everything you need to know about the I-751 removal of conditions. So this is for people who have received a 2-year green card and they were given it with conditions. And this is the process of removing conditions. So I'm really excited about the video. I'm glad you decided to join us. I hope you find it valuable. If you do, make sure to leave us a comment. Make sure to subscribe to our YouTube channel. We'd love to have you be alerted whenever we post new videos, and we hope that this video answers all of your questions about the I-751 process. Let's go ahead and get started. All right, so this, as I mentioned, is the 2022 Guide to Removal of Conditions on Lawful Permanent Resident Status. And first, we need to talk about what is conditional residence. What is conditional residence? So conditional residence is when you have obtained a marriage-based green card. You've obtained lawful permanent resident status inside the United States, either by coming to the United States on an immigrant visa or by adjusting your status inside the United States. And in order to cut down on immigration fraud, USCIS and federal law allows that at the end of the 2 years of your green card, that you're going to have to file a form and get those conditions removed. In other words, you're given sort of a temporary conditional resident status, and this is the process of actually removing the conditions from your green card. This is about getting you on that path to citizenship, getting you quote unquote full lawful permanent resident status, and sort of securing your future inside the United States. So there's a deadline for removing conditions on lawful permanent resident status. At the end of the 2 years, towards the end, those last 90 days, there's a window there where you have to and can apply for removal of conditions. So you can't apply early. You have to file basically 1 year and 9 months after the start date on your green card. We're going to walk through an example of that so I can explain to you how that all works. So let's say Mary received her green card on July 1st, 2020. It would have a start date. It would say resident since July 1st, 2020. So of course, 2 years after that would be July 1st, 2022. And Mary would be eligible then to file her I-751 90 days early, which would be April 2nd. Now, I wouldn't recommend Mary files it on April 2nd. I would wait a week or 10 days. You don't want to file it too early because they could, in theory, receipt it, keep your check, and then go ahead and deny the case for filing too early. So there's that 90-day window I was talking about. It's between April 2nd, 2022 and July 1st, 2022, which is when the green card actually expires. So in that 90-day window, you have to file the I-751, pay the filing fee, and get the case on file. That's how you start the I-751 process. So the name of the form that you file is the I-751. We're going to talk about the I-751 application, but this is a form that is jointly filed. So you'll remember back when you started this whole process to get the initial 2-year green card, there were tons and tons of forms that you had to file. You had to file the I-130, and if you're in the United States, the 485 for the adjustment, the 765 for the work card, the I-131 for the travel document, and then the I-864 for the affidavit of support. You also had to do the medical. The good news is that with removal of conditions, the process is a little bit more streamlined, a little bit more simple, and you're just going to have to complete an I-751. So it's a form that is usually filed by the U.S. citizen and the foreign-born spouse, the person with the conditional residence. You fill out that form, you send it into USCIS along with the filing fee and your marital evidence, and we're going to talk about the marital evidence. You do all that, and then you can wait for the receipt notice, and we're going to talk about what effect the receipt notice has. But the 751 is the name of the form that you'll file. It's the only form that you file, and sometimes people get confused. They file an I-90. An I-90 is to renew a green card, renew lawful permanent resident status for people other than conditional residents. So the only way to get the conditions removed is by filing the I-751, not the I-90. All right, so just as before, when it was our burden to prove that we had a valid marriage, you need to remember when you're talking about the I-751 that it is our burden as the person seeking to have the conditions removed to prove to the satisfaction by preponderance of the evidence that this marriage is ongoing, that this marriage is valid, that this marriage was real, and that this marriage was not entered into in order to obtain an immigration benefit. Now, they are going to look at your case with a little bit more scrutiny because now you're 2 years in. Now you should have plenty of evidence. You know, there's a lot of excuses and reasons why when you are first getting started that you might not have a lot of marital evidence when you show up at the initial green card interview. But at this point, you've probably been together for 3 years. You should have tons of evidence of the marriage. And so when you file your I-751, you really want to make sure that you file as much information as possible. You want to have good, competent evidence, thorough evidence, lots of evidence. I was talking to a guy on my Immigration Answers show, and if you're not following us on there, you should. You can find us on YouTube or Facebook. But if you have been together so long, they're going to want more and more from you. And so this fellow was thinking that he could just mail in a few bank statements and a little bit more evidence. I would say that is the wrong mindset, the wrong attitude, the wrong way to be thinking about this. You want to be able to prove overwhelmingly that your marriage is still ongoing. So we're going to talk about evidence of marriage. We're going to talk about what you need to file, what you need to submit in order to make your application as strong as possible. We're going to go over our marriage evidence list. And if you want to download that list, you can go to www.hackinglawpractice.com/marital-evidence. So MARITAL-evidence. And if you go there, you can download our marriage evidence list. And I'm going to go over that very briefly here with you right now. So every marriage is different, and every marriage is going to have different kinds of evidence. But some of the kinds of evidence that you're going to want to submit, of course, are leases and living arrangements, utility bills, electric bills, gas bills, receipts for large purchases, employee emergency listings from work demonstrating that you've listed your spouse as an emergency contact, employment documents showing a new marital status, mortgage agreements, rental payments, apartment leases, life insurance, medical insurance, automobile insurance, car titles, deeds for any property that you've bought, anything that's going to show you both living together at the same address, all those kinds of things. You can still submit text messages or Skype messages. You know, you want to submit evidence from your Amazon account, or that you have joint Costco or Sam's Club memberships. You can show trips taken together. You can show major purchases that you've made. You can show family photographs. You don't want to send too many, but again, you want to show a history of this relationship over the last 2 years. You don't want to just submit 3 pictures of you wearing the same clothes taken 2 days before you file for your I-751. Think of it as always as a stew, where the more ingredients you include and the longer you let the case simmer, the stronger the case and the better tasting the stew. More likely that USCIS will believe that this is a valid marriage. You can always submit evidence from friends and family, affidavits notarized by a notary that establish that this is a real marriage. You can show social media posts that show you together. There's just an unending list of ways that you can be creative in submitting marital evidence. And again, if you want to download our list, just go to hackinglawpractice.com/marital evidence. All right, so when I first started doing these I-751s 12 years ago, 13 years ago, USCIS would issue receipt notices very quickly, and they would approve the cases in 2 or 3 months. Now these cases are literally taking 24 months. If you can believe that, it takes 2 years now for I-751s to get approved. Under the Trump administration, they added a lot of checks and balances, a lot of quote unquote fraud detection. So these cases are held to a lot higher scrutiny, and that has led to long delays in the processing of these I-751s. So in order to get around that, we turn to the receipt notice. So when you file your I-751, you're going to receive a receipt notice. That receipt notice in and of itself will serve as an automatic extension of now 24 months of your lawful permanent resident status. So it's almost as if the conditions were removed. Of course, they weren't, but that extension letter and your old green card will be your proof of status, your proof of eligibility to work. You will remain in conditional lawful permanent resident status while that case is being processed by USCIS. And so if you need to travel, you would take your old green card, you would take your passport, and you would take your receipt notice, and that would be your proof of status. And let's talk about travel while your I-751 is pending. So you don't want to travel in those last few days of your initial conditional green card. I would say to wait until you get your receipt notice. So USCIS is slow on lots of things, but they are generally pretty good about getting that receipt notice automatically generated, which then, of course, extends your lawful permanent status by 24 months while they process the case. So when you travel, like I said, bring your passport, bring your I-751 receipt notice, and your original green card. When you do all that, You should have no problem re-entering the United States. Of course, you don't want to take any trips more than 6 months because you never want to do that as a lawful permanent resident. All right, so when we file the I-751, we do it with the goal of not having an interview. So USCIS has the power and the authority to waive an interview. And I would say that there's probably an interview in about 35–40% of the cases. So less than half the cases have an interview. And your goal is to submit so much quality evidence. So I'm not just talking quantity, but also quality. A lot of evidence that demonstrates that this is a real marriage. Now, we've submitted applications that are literally that thick. And when you do that, you do it in a way that sort of overwhelms them with evidence. And if you do it correctly, you're very likely to have your interview waived. But if you do have an interview, those can be tough. You could talk about having a Stokes interview, which is where they would separate the couple. So if the marriage has been on shaky ground, or if they submit just a little bit of evidence, or I think there's even an element of some of them getting assigned randomly for an interview, that you're going to get called into USCIS and you're basically going to have to prove up the marriage one more time. Shouldn't be a problem if it's a legit marriage. Shouldn't be a problem if you've been living together and doing the kinds of things that married people do and establishing the records. I would say Stokes interviews on I-751s are pretty rare. Maybe happens in less than 10% of the cases. And again, a Stokes interview is when you separate the couple. So these are the kinds of things that you want to avoid. You want to avoid having the Stokes interview. You want to avoid having an interview at all. Your goal is to try to get the I-751 approved without an interview. And this is one of the ways that I think working with an experienced immigration lawyer, people that know how to put these cases together, really pays dividends, because it's going to make your case go faster, and it's going to make it more likely to be approved, and it's going to make it more likely to be approved without an interview. One of the questions that we get a lot is whether or not someone should file for their citizenship before their I-751 is approved. Now, when I-751s used to take 5 or 6 months, this was never a problem because the I-751 was approved before that window opens for eligibility for citizenship. So, you know, that analysis that I did at the beginning of this video where I explained when you have that 90-day window to apply for your I-751, if you add 1 year to that case, those deadlines, when you get to that point, you'll be eligible to apply for citizenship, assuming that you are still married. So a lot of people now, with the fact that the case is taking 2 years to get the 751 approved, they're going ahead and applying for citizenship. At first, I supported this. At first, I thought that was a good idea. But at the current time, I'm telling people don't do that, because USCIS has made such a mess of it, and they've screwed up so many cases. We've had people show up for their I-751 N-400 combination interview. USCIS is only ready to do the 751, or they're only ready to do the N-400, or they don't know how to do the I-751. It's all been a circus. So our current advice is to wait until the 751 is approved until you file for the N-400. The only exception to this would be if someone was in an emergency situation, for instance, if they're trying to get their parents here to the United States and they needed their citizenship sooner rather than later, or for some kind of travel reason or other reason, life reasons, they wanted to get their citizenship, we would have them file that sooner rather than later. All right, so let's talk about when people file their I-751s late. A lot of times people will miss that 2-year deadline. It happens actually more than you think. I've had people file this I-751 2 years late, 3 years late. I even once had a fellow from Canada apply 9 years late. And when you find yourself in that situation, you are going to have to give a good example or a good reason as to why you failed to file it on time. Now, in my experience, USCIS has almost always forgiven this. They don't really hold people to that higher standard. They sort of take any reason as a reason. Now, of course, you shouldn't plan on that. You shouldn't apply late on purpose. But if you find yourself having missed the deadline, or as I mentioned earlier, sometimes people file the I-90 instead of the I-45, this can be fixed. It takes a little bit extra work. Again, this would be a situation where I'd probably recommend using an immigration lawyer to help you through this part of the process, to have them handle the 751, because you're going to have to explain to the satisfaction of USCIS that you are trying to follow the rules. You just missed the deadline and you didn't file it on time. Sometimes, sadly, the U.S. citizen or LPR spouse who sponsored the foreign national for lawful permanent resident passes away. At that point, you can file for removal of conditions. You can demonstrate that the marriage was valid, that the U.S. citizen or LPR spouse, the petitioner in the original case, had passed away. You can file an I-751 on your own when the spouse has passed away. Now, let's talk about filing for the I-751 after divorce. In our office, we talk about this as an I-751 solo. So we call them either I-751 joint which is the traditional way that people file it, that you file that I-751 with signatures from both parties. But our office has handled a ton of cases where the U.S. citizen and the foreign national have divorced. The marriage is no longer ongoing, and the foreign national is attempting to get conditions removed all on their own. Again, we call these in our office an I-751 solo. The strongest way to do that, the more frequent and popular way to try to do that, is by demonstrating that it's a good faith marriage that just didn't work out. And again, you're going to have to prove up, just like you would in a marriage situation, you're going to have to prove up that the marriage was real, but that for whatever reason, the marriage did not work out. What you're going to have to show is that the couple loved each other, that they built a life together, but at the end of the day, the marriage didn't last and they decided to get divorced. In order to avail yourself of this I-751 good faith exception, you're going to have to demonstrate that the divorce is final, or you're going to have to be pretty darn close, because they'll send you a request for evidence to demonstrate that the marriage is over. They can't approve an I-751 solo if the marriage is ongoing. So you need to keep that in mind. And so a lot of times when we have these consults, there's a lot of moving parts. People have to think about the logistics of the divorce. They have to think about the filing of the I-751, and there's moving parts. Sometimes you file the I-751 and then the divorce is on file. So that's, again, a situation where you're going to want to hire an attorney. It can actually get pretty close, because sometimes you get divorced right before the 2 years are up, and you're thinking that they might approve the case and not know that you're divorced, and that can be its own mess. My wife, Amani, who I practice with, handles a lot of these, and she's very good at these, but they can really, really be a mess. Now, when you file the good faith exception, you still have to submit all that evidence, but the best evidence of all is if you can get the U.S. citizen or LPR petitioner, the person who sponsored you in the first place, to participate. When people contact our office, I always tell them, think of this as red light, yellow light, green light. Red light means my ex-spouse is going to do everything they can to screw me. They're trying to kick me out of the country. And that situation happens more often than you might think. Yellow cases, the former spouses stay out. They don't care one way or the other. They're going to just stay out of it. And then, of course, the green light means that they would help any application. They would file an affidavit going through the relationship and explaining how it was real marriage, that it just didn't work out. That also happens more than you might think. So a lot of times we'll tell people, before the divorce gets too hot and heavy, let's try to get a statement from both you and the U.S. citizen or green card holder petitioner, and get that statement from them for two reasons. One is we want to nail down their story. We want to make sure that this was, in fact, a good faith marriage. And almost equally as important, we want to make sure that if the USCIS comes a knocking on the door for that foreign to the U.S. citizen's house, that we already have their story locked down. So then if they change their story, we have a sworn affidavit from them that said that the marriage was valid. And then we can argue, well, this new statement that USCIS has obtained was just obtained under duress because the person was scared and USCIS officers were mean to them. So getting that down on paper and sworn in front of a notary at the beginning of the process is one of the smartest things we do. And it's one of the best ways to try to demonstrate that the marriage was real. You're still going to have to prove up, through all the other evidence that we talked about earlier. It's just the same amount of stuff, but you're going to have to do this extra work of demonstrating why the marriage didn't work out. So sometimes you have to explain about infidelity. Sometimes you have to explain about why it didn't work out, and it can get a little messy. So we try to stay sort of high level. We try to stay above the fray. We try not to get involved in any fighting between the two spouses. And we just do what we can to try to get the I-751 approved. So there's basically three exceptions to the rule that you have to file that I-751 jointly. The first would be if there would be extreme hardship. If we can show extreme hardship to the beneficiary or to a loved one of them having to leave the United States, that would be one exception. We already talked about the good faith exception. That is where the marriage was valid, it just didn't work out. And then if the foreign national was the victim of battery or extreme cruelty, if it was an abusive relationship, there's a waiver available for that as well. So we've handled all three of those kinds of waivers. They're actually very interesting cases to work on. I think it's definitely a situation where you want to have an experienced lawyer help you with that. I actually would just refer all those people to Amani and her team. We work on these cases a lot, and we pretty much treat them like asylum cases, like we're battling to try to keep the person in the United States. And the reason for that is because if your I-751 is denied, you're going to be headed to deportation court. So this is not the time to screw around. This is not the time to sort of wing it. This is not the time to file a thin case. You're your remedy if you file for removal, if you file for removal of conditions and you get denied, is you get to removal court, you get to deportation court. That's a real problem, obviously. And then you're going to have to prove to the satisfaction of an immigration judge that the marriage was valid. And of course, their job is to deport as many people as possible. So if you can, you really want to avoid that as well. That can be a big old mess. So that'll do it for the I-751. Hope you found it helpful. These are all the kinds of things that we talk to our clients about. This is the kind of work that we do. You know, we handle a ton of marriage-based cases overall. We always love working with our clients who we helped get their original green card, and we like working with them when they have their conditions to remove. And of course, if that marriage has gone badly and we represented both of them, that can cause a little bit of a problem for us and for the spouses. We, of course, never help anyone get someone deported. So we'd be wanting to fight for the foreign national. But if the U.S. citizen spouse, our former client, would object, we would have to get out of it. So it can be a little bit messy when the marriage goes south, but these cases are still winnable. Overall, we really like helping people get their conditions removed. It's like I said, an interesting case to work on. Now, if you need to get a hold of us, let me go ahead and give you that information. You can email us at info@hackinglawpractice.com. Our email address is info@hackinglawpractice.com. Like I said, our website, www.hackingimmigrationlaw.com. Our phone number is 314-961-8200. You can find us on YouTube. And, you know, we have a live show most days. You can also find us on TikTok at Immigration Hacking. And then we have our immigration Facebook group, which is called Immigrant Home. We'd love to have you join us there. Thanks for watching the video. Please click and share. Make sure you subscribe. And we really thank you for watching.